Just the agenda, do we have the minutes?
Yeah, we have minutes, it's there.
Oh,
You guys have the minutes? It being a little after 7 PM on Wednesday, February 18th, 2026. I'd like to open the zoning board of appeals. Can I get a second?
Second.
All in favor?
Aye.
Since we have to wait a couple minutes before we can do our first, first person, we can do minutes. We have 11:05 minutes, 12:03, and 12:17 minutes. So we'll start with the 11:05 minutes. How does everyone feel about those?
That's fine.
Can I get a motion?
I'm making a motion to approve the minutes of November 5th, 25.
Can I get a second?
Aye.
second.
All in favor?
Aye.
Aye.
There we go. I feel like we've been gone for a while. We gotta get back, get our feet back underneath us. Next one is December 3rd, 2025.
I move that we approve the minutes for the December 3rd, 2025 meeting.
Can I get a second?
Second.
All in favor?
Aye.
Aye.
Very good. December 17th, 2025.
I move that we approve the minutes for the December 17, 2025.
Can I get a can I get a second?
Second.
All in favor?
Aye.
Very good, that's done. Might have moved too fast. We have to wait 2 minutes. Our David's on there? Is that our David? On the board?
I don't know who.
Oh. Oh, okay. Oh, okay. Who wants to read? I don't even know how it's gonna come out. Because there's no notice. One more minute. Do you want to read the notice? Or no notice? Sure. We don't have a notice at all, do we?
No, legal said that we didn't, and
So just read whatever's on the agenda. Oh, yeah, that's the front to back. Yeah, let's wait for it.
Mr. Chairman, do you know if anybody from the building inspector is going to be here?
We have town council.
Okay.
Matthew's
but-
up there.
Oh, okay. So our town council is here. Do you concur that we didn't need to publicly notice this hearing?
Not sure what you mean. I'm looking at the agenda that's posted on your website, and it contains a notice of the public hearing. It says 7:10 PM, appeal of electrical permit issued for map 74 lot 4, Indian Pond Country Club, electrical permit to Russell Tyler, attorney John J. Danahy, which is all of the information that I have exchanged that comports with Valerie and Jean, the messages I've had with them. So as far as I understand it from what you have, this was a validly posted public meeting containing a hearing at 7:10 PM.
It didn't have to be published in the local newspaper then, as most of our other hearings are. Usually there is,
That
This
I'm not
pub-
aware of. I don't know whether that was part of it. I've only
That's it.
engaged with,
it did not.
whether we need to get this on the agenda and how it's going to
This
go.
is
I
also a
don't-
continuance.
right, but Val said we didn't need to post a public hearing notice.
Yeah,
just
this is a
to post
continuance.
the agenda.
If
It was
you
on the town
previously
website.
opened the hearing and this is a continuance to a date and time certain, that would not require another round of advertisement. That's why you can only continue to a date and time certain, so that anybody who looks at the minutes or hears anything about it would know when, where, and how the next hearing session is going to take place.
Are we ready? Because I think we hit the 7:10 mark. All right, being said, can we read it?
An appeal of electrical permit issued from map 74, lot 4, Indian Pond Country Club, electrical permit to Russell Tyler on 6/3/2025. Attorney John J. Danning.
All right, make sure the little green light is on.
There, can you hear me? Good, all right. Good evening, Mr. Chairman and fellow board members. My name is John Danahy. I am the attorney representing the applicant or the appellant, which is EBFI LLC, a direct abutter to the golf course. Many of you know Fred Tonsberg, who's also sitting here with his wife. This is kind of an interesting case, to be candid with you, because what we're appealing is an electrical permit that was sought by Russell Tyler back on June 3rd, 2025, a year ago. And the reason why it's interesting is because what it's relating to is a building that is on the premises of Indian Pond Country Club. And I provided you a little background history. Obviously, I think many of you board members know about the history of the golf club through a special permit being able to be built. And a lot of good things came out of it, no doubt about it. The golf course, subdivision, pool, and facilities that obviously people were using. But one thing that happened back in 2001, along with what was presented to the zoning board and approved through their special permit, was that they added other buildings to the facility, buildings that were not necessarily detailed or, described. And so in 2001, April, there was a building permit that was requested by Kevin Tonsberg on behalf of the golf course to build a two-story garage and also a barn. And that building permit, which was 01-086, which is a part of the packet, which happens to be Exhibit A, details the application for it. And so that's the building. That's the building that ultimately Mr. Tyler was looking to connect, and what he was connecting based upon what we submitted as a part of Exhibit, I believe it's B as in boy. I just want to make sure I get it is to put together a 200 amp electrical service to that building. And obviously, from our perspective looking at it, when you have a structure that's been in existence for a fairly long period of time, in this case, the two-story garage / barn for 24 years, used for some capacity as to what we're not really sure, electrifying it changes it. It changes the use, because the use that was there for 24 years now is going to be altered. And that's the big question that I think is important for the board to tussle with, because this is a part of a special permit process that whenever there's a modification, whether it's a major modification, saying I want to build this or that, or a minor, the applicant, or rather the, in this case, the applicant being Indian Pond, should come before this board to explain it to the board, so that the board can take a look at it and see whether it is a minor change or whether it's a major change needing other reviews. And when you take a look at it from that perspective, why is that set in that kind of structure? First is it's put into the special permit that was issued by the board back in 1997-98, but also for health and safety reasons, to kind of review and make sure that, yes, indeed, things are being built properly, that there is some access. What if there's a fire? Can you get access up there? Is the fire department able to get up there? For those various reasons. So what ultimately happened is, and just so you have an orientation of the structure, what was built back in 2001, if I could just show you and I realize that's not beneficial for town council, but what it is in essence is a depiction of, I think it's a Google Earth looking down, basically on the bottom portion of this is the clubhouse. And I can represent that by showing here. The clubhouse is this area. And then the parking lot to the right of the clubhouse when you're facing it, parking lot to the left. And the building that was built back in 2001 was built up near the driving range. You know, the driving range is depicted in this area here, and the building structure 01-86 is this area right here. That's structure. You can just see there's a roof line right there. So that's what we're talking about. So, getting to the permitting here and why it's significant. Part of the problem with the original building permit, 01-86, is that there were never any inspections. If you take a look at Exhibit A, there's no follow-up on it. One of the things that's brought to our attention from getting the building file, or the materials from the building file, I believe, and I'll correct that, it may not be the building, I think I got it from Freedom of Information, only to get materials. So I'm assuming it's in the building file, but the application indicated that it was going to be 24 feet by 36 feet. Okay. What we submitted as Exhibit C happens to actually be a rendering of what was being proposed to be built. So they pushed it out by 2 feet, 26 by 36 feet. And when you look at the rendering on Exhibit C, it also shows that there are 3 bays on one level, 2 bays on the other. And that's the 2-story garage barn. But the reality of it is that's not what they built. And when you look at Exhibit D, you can see what I'm talking about. So if I show you, just as we go through here, the renderings. And you might recall seeing these before. Yes, they were. They were in another zoning hearing dealing with the maintenance building and the other parking lot. This is the actual structure that was built. And the difference, when you take a look at it, is instead of having a 24 by 36 kind of square or rectangular structure, what you're finding is that they added actually outward. And what I'm referencing to is, if you look at the very first photograph, there's this structure here. This area here, and this is the backside, I believe, of it. And then you can see it again, so I'm trying to talk into the mic here, this area here. So obviously what was built wasn't what was proposed or submitted, and I think when I put into the letter, and council probably either can agree or disagree, but a structure was built. We call it a non-compliant structure because it wasn't built pursuant to the building permit, wasn't checked. It's allowed. It's a structure that should be able to remain after 10 years. And we're not saying anything wrong with the structure, just that nobody knows what the structure's for. So now we get to 2025. They're connecting electrical service. We don't know what the building is. We don't know what's been used for. From these pictures that I have in front of you, clearly they've been doing storage. Well, that's allowable because that's what they wanted in the barn. But I will say the most recent one here, the concern might be, that's certainly an inquiry, is there seems to be some fertilizer containers that are on the outside. So obviously what's on the inside? That's a question nobody has an answer to unless it's Indian Pond, who would be here before you to give you an answer. So our perspective is that, you know, they should come before this board because there's a change. The change of use is they have electrified it. Now, I should give you another fact that is true because it's changed since the application, the appeal from June 30th. Since June 30th, the Indian Pond did have space at the maintenance building that they were renting. They vacated it November 30th, so no longer in that building. So all of the maintenance activity that was going on next door, whether it was from all the parking there or whether it was the trucks, everything, is now somewhere on site. So electrifying a building, the maintenance is somewhere, the carts are somewhere. Obviously, it certainly begs the question of what's going on. shouldn't Indian Pond come before the board and say, hey, this is what we did to the building? Maybe they just put lights in there. If that's the case, it's a minor change, and if lights just to be able to see the inside, maybe not. But I think that's where the board should be actively looking at it, because it's your purview. So that gets me to, okay, the electrical permit. And I know there could be a difference of opinion of, is there a change of use by it? But our position is, well, yeah, there is, because something's going on that wasn't there for the past 24 years. And part of the problem with the electrical permit is, it's got to be, my understanding is it's got to be premised on a building permit. There was no building permit. It was from 2001, but unless you continue it and you get a certificate of occupancy at some point, the building permit is now abandoned, or it's null and void. You have 180 days pursuant to the regulations to do something or ask for an extension. That has not been done. So now you got an electrical permit that's issued based upon what? And they're electrifying a building. So we're seeking your help here to be able to say to Indian Pond, they should be coming before the board to say, what's going on there? Our position would be that it's electrified, that they should probably be prevented from electrifying any further until they come before the board, and explaining exactly what they're doing. And at that point, the board will have input to be able to see exactly and go through what its due diligence. Part of the problem is, and I think, sometimes people like to build first, ask for forgiveness later. It's just not a great way of managing things, and especially trying to make sure that people do the right thing. And I think, sometimes that emboldens people. But I just think that in this case, that's really what we're seeking. It's nothing complex. It's just basically trying to suggest to everybody here that there's transparency, what's going on, what are you doing? And if it's something innocuous, then the board can say, that's what it is. But right now, nobody knows what's going on. I think that's a major flaw in the problem, because it's in violation of their special permit.
Thank you.
Thank you.
Any quick question for Attorney Danahy before I move to our town council real quick? I'm going to do town council. If it's a quick question, you want to have him while he's right there.
No, these would be substantive.
Okay, hold on.
Not procedural.
Town council, do you want to do your side now?
I'm happy to address the question, Mr. Chair. I don't know if there's anybody else there who is looking to speak either in favor or in opposition to the appeal before you move to, thinking about it, or you want to have any discussions with me. I usually say it's best for the board to get any factual information they want to gather from anybody who wants to speak before, you have an attorney weigh in, so the board doesn't have any concerns that they're tailoring their comments based on whatever I might say.
Very good. All right. If you have any questions, take it.
Oh, thank you.
Go ahead.
Just so I'm clear, Exhibit C, this looks like a two-door garage building. Is that right, Exhibit C?
Yes, upstairs,
that
downstairs.
came from the building file. It should be 2 pages. The first page would have 2 garage, and then the second page would have 3.
Oh, the 3.
3.
Okay, so it's these 2 drawings that represent
Correct.
what the town approved in 2001.
That's our belief, because that's what we got out of the file, yes.
And there's a corresponding building permit for this, or was it part of a comprehensive permit?
It was, I'm sorry, I interrupted you.
Because comprehensive permits can at times approve multiple buildings. So I'm just trying to learn, was it part of the Indian Pond Country Club's comprehensive permit, or did they seek a separate building permit for this?
So if you look at Exhibit A, that's the separate permit that they sought to build the building. And it should say location of construction, 60 Country Way. I can give you mine if you'd like.
Or just hold it up so I can try to...
Yeah, it should be like this with a bunch of empty boxes.
I don't
think I
have
have that either.
I don't think I have.
I'll present it to
Yeah, it's
the
in-
Madam Clerk.
Is it in there?
There's nothing to about.
Okay, you found that, okay, I was looking for
Oh, I
it.
don't,
It's some
on the
stuff's
back
from the back
page.
page, yeah, the front and back. But I didn't see
You
it.
can have mine. If I may give this to the Madam Clerk, if that's okay.
I'm good.
for some reason, it's just not part of my packet. Oh, thank you.
I don't have either. You have it.
It's on one of the back pages.
Yeah, I don't have it. Just file it. I mean, I know what they look like, so.
This is very familiar. I think this was introduced during the country club's comprehensive permit application for their new maintenance building. Is that true? Do you
I
recall?
believe it was used, I think I used it back in the modification, I think they filed for the maintenance building 2 years ago. I'm trying to, yeah, I think it was 2023, 24.
And my recollection is that there was more writing on it.
That could have been, there are a number of building permits, but that one is
Are
actually,
you asking for the actual comprehensive permit?
yeah.
No, I'm looking at the Exhibit A now, the 01086 permit dated.
Yeah, and that's
4/13.
specifically a reference to that permit itself. It's not a part of the comprehensive permit that would have been granted in 1998.
And it doesn't indicate what its intended purpose would be, whether it be a commercial purpose, a residential
It
purpose.
has in the remarks, it says two-story garage barn.
Yeah, but a garage can be a commercial garage. Doesn't necessarily mean a residential structure. Do you know if it was intended to be a residential structure?
That's the only information we have. There's pretty scant information about what they were applying for and lack of follow-up.
But no certificate of occupancy was ever issued in connection with this building permit application?
We do not have any information that, I've asked for information from the building department and nothing was provided. So the short answer would be no, because it should have been on that.
And do you have any evidence that it was ever occupied for residential purposes?
No evidence whatsoever, no.
Do you have any evidence that it was ever electrified prior to the electrical permit?
Nothing in the file to indicate that there was any kind of electrification other than the most recent one from last year. That's all that we have.
Does it have water? A water connection?
We have no information on that either.
Does it have-
Nothing in the file to indicate one way or the other.
Is it connected to the sewer?
Again, I would have to defer to the fact that if it's not, there should be something in the file to indicate otherwise, and there's nothing to indicate that it's connected to the sewer or their septic system.
And the building is owned by?
It is owned by the golf course, Indian Pond Country Club.
And Kevin Tonsberg's relationship to the golf course is
So my
what?
understanding is he is the son of the developer Frederick Tonsberg, not the individual here. And I'm not sure if he is, I have not looked at the corporate structure as to where he may be, whether it's Indian Pond or anything else, but I understand that he's the one who applied for that building permit.
Weird.
And I noticed that you applied about 8 months ago,
Yes.
and I know there were a couple of delays, but it's still, I saw you ask for a delay from January to this date. I just don't know what took so long. Was there a reason for that?
So unfortunately, we filed promptly, June 30th. I walked it down to the town hall. And it was accepted, which was fine. And I did communicate subsequently as to trying to get a hearing date. The downside is, and in my understanding is, and I can completely understand, having been involved in town government myself in my own town, is that I think the building inspector had left the position. There was a temporary who came in to help out. And for whatever reason, I did have communications with the former temporary building inspector. I did get an email communication because I said I wanted something in writing back in October. And I did send some letters requesting an update on the hearing date. I think there was one in September, and I think there was another one in November. And I will say the zoning secretary has been nothing but wonderful helping me out. So I think the delay primarily is probably administration of filling in positions. Otherwise, I was more than happy to be here back in August or September, October, November. The last date was moved for me, which I appreciated for personal reasons. But that was that was on my part.
And do you believe this board has jurisdiction to hear your appeal?
I do, and the reason is because it's a use issue, and I think that's really the issue is, does electrifying a building potentially change the use? And I think the answer is yes. If a building has been operating something different in this context because of the special permit, now we know for there's going to be electrified for what? And again, I can give you potential examples, but I think the fact that the maintenance building is no longer functional because they vacated it, it certainly raises issues. Then it's electrified for something other than what the use was prior, which was storage. And clearly from the pictures here, they had outdoor storage and stuff, which I get, but now electrifying it does change the use, and I think that tips it. I think that tips it for the board to be able to say what's going on.
I would agree with you that you could speculate about it's being used as a maintenance building, but I don't want to do that. I want to just focus on this building. And you keep saying a change of use. It sounds to me like we don't have any idea what it was used for. I mean, if we don't have any disclosure on the building permit, we don't know if it has water, we don't know if it has sewer, you know it didn't have electricity. What else don't we know? There's a lot we don't know what the use was. So I guess that's my question. If we don't know what the use is, what is the proposed use? And we don't know anything.
I think
I agree with you. It seems.
I think that's a dilemma that the board is tussling with because, again, you have a lack of information other than it's been electrified as of last year. And you're correct, I would say no speculation. The board shouldn't be speculating in the future. That's a bad precedent. It's actually not good. But I would say that clearly Indian Pond really has a duty to really explain to the town and the board exactly what they're doing with this building if they're going to electrify it.
Oh, and frankly, I believe the people who live in that neighborhood. I mean, this is a residential neighborhood that bought homes, thinking they were going to live next to a nice country club. They had a maintenance building that they disguised as a single-family dwelling to sort of lend to that vibe. And now, and they came and they asked for a brand-new maintenance building, and it was denied. I don't know what the status of that appeal is. I don't. But I know this board denied it. And if they did not renew their lease for their old maintenance building, again, it does seem coincidental. I don't want to speculate, but I do want to know what the proposed use of this is before it goes any further.
I think that's...
And if it means de-electrifying it, withdrawing the permit, that's all what I'm in favor of.
I think that's certainly an option the board could entertain of saying, until they come forth with what they're doing there, taking the electrical and I say shutting it off, putting it, it would be a step. Clearly, I think there's explanation that should be made by the golf course to say this is what's going on because of the lack of information. And again, it's their obligation under the special permit to do it. That's really what it emanates from. And I think, it's only fairness for transparency to be able to say, this is what's going on. Again, we can speculate, it could be innocuous, it could be something, it could be major. Bottom line here is that's their obligation to at least do it. And that's the only reason why, when I did communicate with the building inspector, the substitute, I was saying, again, he had difference of an opinion, but the opinion was electrifying does change things. And so now it begs the question, what? And I think those are questions that the board and people should have answers to and take it from there.
But you're not, just so I'm clear, you're not really questioning the electrical inspector's judgment about, is it an appropriate?
No, it's not for the building component. In other
The
words,
actual-
they
or the building.
installed it, and that's fine, because that would be another avenue if you thought that they didn't do it properly. I'd be like, I think that's through the building code, and you have to go through the AED.
So you're really approaching this and coming to us from as the body that has jurisdiction over, I guess, this development because it has a comprehensive permit?
Correct.
That's why you're here?
Correct.
Okay, thank you.
Town council, I have a couple questions. Let's say we, as a board, we collectively said that this is a major change to this, it's to a special permit, not a comprehensive permit. If we said this was a major change, a couple questions I have is, the application for the permit was given to Kevin Tonsberg. Now, I find that weird because this is a business entity. Wouldn't it have to be written to Indian Pond Country Club in order to get the permit, because that's the owner of the property? In other words, I'm trying to say is having too many deficiencies as this went, does it effectively make everything null and void? Because the barn is owned or built by Kevin Tonsberg, or the applicant, and that's not the owner of the property.
So, Mr. Chair, I don't view it as a material issue. If you look at what's been marked as Exhibit A in the submission,
Yep.
you can see that the applicant is listed as Kevin Tonsberg, but the owner is Indian Pond Country Club. And that's frankly not uncommon at all, because obviously there needs to be a person acting on behalf of the corporation. So I think that there's no real ambiguity here. I think everybody
Okay.
knows who the players are and who the actual owner is. So I don't think anybody, especially given the number of applications, whether to this board, to the building department, or other town departments that relate to Indian Pond Country Club and Kevin Tonsberg, I would view it very unlikely that there would be any sort of confusion arising from that sort of thing.
And then keeping on Exhibit A is, to me, it makes sense that nothing's been signed off on this building. So this building's never been finally inspected. Like, there's no sign-offs on initial construction, there's no final, there's no nothing. Like, this has never been finished out.
So to be perfectly honest with you, I have no idea what the provenance of this document is. I don't know if this is the application, or if this is the final one that would have been posted on site. It might be hard to figure that out. It's from, over 20 years ago.
Right.
But what I would tell you is that the technical compliance with the terms of the building permit, whether the plans are sufficiently detailed and accurate, whether it's supported by an application from a licensed contractor who's capable of doing the work, those are all typically matters that are addressed to the building official under the building code. And when there's a dispute about them, as Mr. Danahy just referenced, they're typically brought to a separate administrative tribunal called the Building Code Appeals Board. That body, which is within the state government, interprets and applies and addresses questions about how the building code should be applied as it relates to a request for a building permit. In the zoning context, I agree that this is typically not an appeal that would be brought to a zoning board, because the actual issues here seem to be related to the contents of a building permit, when it was enforced, whether the electrical permit was validly issued, whether that's as a type of building permit or an action taken by the local inspector of wires. There's also a separate administrative appeal track for those kind of determinations, just like with the Building Code Appeals Board. It's called the Board of Electricians Appeals. And that here is technical issues which relate to whether an electrical permit should be issued, can it be issued under the current version of the building code that governs things, similar to that. So the questions I have about that, or I think what the question is aimed at is, what kind of information would you typically get on something like this? And my answer would be pretty little, because normally that would get worked out in the first instance between an applicant and the building inspector or commissioner. As soon as they get a permit, if they feel it doesn't have enough information, they tell the applicant, I need more information to make a final decision on this. And then if they say no, you might get an appeal if the denial is in part based on a zoning determination. But here, there don't appear to have been any zoning issues raised with respect to the building permit, nor on the application for an electrical permit. And I want to clarify one thing. The associate member asked Mr. Danahy, do you disagree with the interpretation of the building inspector? And he said, no. I have to remind the board, this is an appeal from a determination. They wrote to the building inspector and asked him to make a zoning determination as to whether the electrification of the building changed its use. His opinion was that it did not. That is the appeal that's before the board. They are asking you to overturn the decision of the building department. So I understand that he might be saying, you know, with charity to the building department, I understand that he's trying to resolve a difficult issue, but as a technical procedural question, they are necessarily disagreeing with the building inspector's determination, and that is how they came to be before the board.
With respect to council, I think that the applicants were instructed that they had to appeal to the zoning board. So I don't think that.
But the building inspector's determination was that he was not going to take any action, and he didn't view it as a change of use. They do view it as a change of use, and they are asking for action to be taken. So necessarily, that means if they want that to happen, the building inspector told them he's not going to do it, so they're coming to you, asking you to overturn that determination and order the building department to take a different action.
I guess, I think they're asking us to overturn the determination that it's not a change in use. We don't know what the use is. There never was a use established. So we are seeking, I don't mean to put words into the applicant's mouth, but it seems that they are seeking in the very first instance, now that we all realize it, that no use was ever established for this structure. It can exist in perpetuity under the 10-year rule, I understand. But I think that since no use was ever established for the structure, other than what's on Exhibit A, no follow-up ever occurred, no certificate of occupancy was ever issued, that we should exercise our discretion and determine, in obviously the first instance, what the use of this structure is. And I think we have the discretionary authority to do that.
I'll tell you right now, you don't. You're a zoning board of appeals. You're not a zoning board of the first instance. You handle appeals from the building department. So
That's what they're trying to do. Again, I think you're putting form over substance here and just kicking this can down the road again, as we have done continuously when it comes to this development. And I, for one, am tired of seeing my tax dollars wasted in court fighting these people when they are simply asking us to do something that I think is within our discretion. I don't think they'll appeal it if we do it. I think if we don't do it, they will appeal it.
So, I say this to zoning boards all the time. The first thing is that obviously everybody comes into this knowing what the backstory is. I would counsel you to try to put that out of your mind as much as possible and focus solely on what's been presented both to the building department and to you. Because you don't generally want to make a decision on an appeal based on considerations that are solely within your personal knowledge and not contained in the record of appeal that's before you. It's an extraneous consideration, and it's usually not an appropriate basis to make a decision. So that's number one. Number two, I understand the impulse to prioritize substance over form, but people who come before the zoning board are not served by the zoning board failing to note what it legally has the power to do or not do. If you try to take an action that is not in fact within your discretion and is outside your jurisdiction, it will be an illegal action. And that does not serve anyone's interests. It doesn't serve the interests of an appellant. It doesn't serve the interests of anybody who might be affected by an order of this board. It doesn't serve the interests of the board, and it doesn't serve the interests of the town. There are certain things where, when they're not really questions of form, they're questions of jurisdiction and legality. So to the extent that what the appellant is asking you to do is take action on an electrical permit based on what they contend is a necessary change of use under the building or electrical codes, that is not within your jurisdiction. To the extent that they are saying the building inspector made a determination that we have not supplied any information that shows that the use of this structure, which they concede is lawfully present on the property, albeit due to its age and not due to the appropriate course of permitting in the first instance, they are saying the building inspector's determination was that we did not submit any evidence that shows a change of use in the structure other than the electrification, and that in his opinion, electrification of this structure alone is not sufficient evidence to show that there's been a change of use. What you're going to have to do as a board on this appeal is determine whether that determination should be overturned.
I thought you told us we don't have the legal right to do that.
Only to appeal against,
Again, you have so confused, in my humble opinion, the issue here. You started out by telling me, the associate member, that, we couldn't do it because it would be an illegal action. And then you come around the bend and say we can do it.
It's because there are two separate issues. One is a request for enforcement to the building department. The appellant is contending that the owner of this property, Indian Pond Country Club, has violated some term of a special permit that was issued back in the late 90s or in 2001. I don't see that special permit contained within the application file either.
And I didn't hear them say that. I've heard them say that the use has never been determined.
I understand that, and if you could please let me finish. When they say the use has never been determined, that is an argument. It is a legal conclusion. It is not a factual allegation that any individual can make. They need to show, if you want to show what a use is going on the property, you want to say, this building's being used as a single-family residence. You would say, I see a parking driveway. I see people coming and going. It externally appears to look like a home. Therefore, I, as the building official, can determine the use that's being carried on in this property is that of a single-family residence. If I see a single-family residence with two separate entrances, I see multiple cars, I see people coming and going at different times of day, I would advise a building official, you could form the conclusion based on what you have observed and seen that what you are seeing is a multifamily, a two-family duplex that's illegally being operated in a single-family zone. And that's the difference between what we're talking about. So there's no first instance determination at the Board of Appeals. The first instance determination is made by a building official who can go out, who can gather information and evidence, physically observe things, and then say, as a matter of fact, I witnessed these events, and this is what was happening, and thereby determine what use is being carried on. So to return, though, to what I was saying is, there is a request for zoning enforcement to the building official on the basis of a special permit, which I have every reason to believe exists, and I have no reason to believe the appellants have mischaracterized in any way. But I've not heard any mention of the fact that electrification of this building was prohibited as a condition of the issuance of that special permit. I haven't heard any information about what use is being carried on. They simply say, we don't know what's going on there. And the building official's response to that was, so what you've been able to provide me is with information that there was an electrical permit pulled for the building and issued. That electrical permit does not appear to have been appealed under either the building code or the electrical code. So to the extent they are asking this board to take action to suspend, modify, revoke, or take action on that electrical permit, it's not appropriate for this board to do, because this board addresses zoning issues. It doesn't address building code issues, and it doesn't address electrical code issues, and it doesn't address fire code issues. Those all have separate administrative pathways. That's box 2. Box 1 is, you have a request for zoning enforcement, the building official said that he would not take action on it, and you need to determine whether or not you want to overturn that decision. Other actions on the issuance of the permit, whether it was validly issued, whether it complies with the building code, whether it should or should not have been issued, are really beyond the purview of this board, except insofar as they relate to zoning issues. And because the permit was issued, we can conclude that the building department did not conclude that there were any zoning issues with the application for that permit, because if they did, they would have denied the permit, not approved it.
So, question moving forward. Obviously, there's an appeal in front of us for the electrification of the building. Can we use basically the lack of knowledge of what the building is, it's called a barn, and yes, it was given electrification, but can we use that as a trigger to say, since we don't know what that building is, and the special permit didn't really have that building on the original special permit, can we request that, this is a major modification, we would like to see and get knowledge of this building? In other words, the permit's been, changed without coming in front of the zoning board, and request that they come back and show us exactly what this building is, so that they aren't changing it under the guise of whatever. And we say, we want to know what this building is. If you are storing more than just storing, sticks and rakes, a fire department still has to take a look at it. The health department has to take a look at it. Basically reopening basically the special permit because they violated it.
So what you would need to do there is, there are a couple of ways you could do it. The first thing you could do is, someone could make a motion to overturn the building inspector's determination that the electrification is not sufficient evidence of a change of use of the building for zoning purposes. The difficulty there that I would counsel you with is that you do not have very much information about what, if any, use is being carried on there.
Right.
And so I do not know what you would base your decision that the building inspector was wrong upon. You have an absence of evidence, really, more
Even
than...
if, not to interrupt you, but even if we did say that the building inspector did it correctly, but it's now coming to our attention that this building is basically changing it's changing its use slowly, and they're gonna possibly come ask for forgiveness down the road and get ahead of this before something, we don't know if it's up to fire code standards at all. We have no right sign off on it, and it has a 200 amp service to it out in the middle of the woods.
I think there are two ways to do that. The first is, I don't know what, if any, subsequent follow-up was undertaken by the building department and the inspector of wires to confirm what work was done, whether it was done to code, if it was appropriate, if there are any collateral inspections that need to happen with that. My understanding is there's nobody here from the building department who's able to tell us exactly what the status of those investigations, if any, is. So you could continue the hearing and wait to hear from them. You could continue the hearing and invite the owner to attend, and then, based upon whatever information they may or may not give you, or whether they even agree to appear at all, would give you some basis to make a determination as to, what's going on the property, because the refusal to appear and testify allows you to make some inferences about whether what they're doing is in comportment with the special permit and the restrictions attendant upon it that when it was issued. You could do that.
Could we suspend the permit, meaning put it in basically in limbo? In other words,
I don't think you have a basis to suspend the permit.
yeah, I don't mean,
there's
deny
no-
it. I just mean, since it hasn't been final checked, we don't know the status. We know that they were given a permit, but I don't know if it's gotten a final.
Right, and the
Has
problem
been
with that
filed.
is that you typically wouldn't get any of that information, because a question about the propriety of that kind of permit wouldn't come to you.
Right.
So it's, some of the information that's contained in those final inspections may be relevant and could be presented in a zoning appeal. You know, for instance, if they said, on our application, we said we want to electrify the building and we're changing its use from a garage barn to, I don't know, a clubhouse or something. We're going to use the space in a different fashion. That could be presented to you and you could say, on that basis, you're substantially changing the use of the building and that violates a term or condition of the special permit that you were issued when you were allowed to construct this building. That would be different, but even then you would be coming in after the fact. And so I don't think that you have jurisdiction to take action as a zoning board to overturn, modify, or revoke an electrical permit.
Okay.
You do have the power to enforce terms and conditions of a special permit that was issued by this board.
I thought you said earlier we could make a motion to overturn the building inspector's permit authorizing the electrification of the structure.
That's not what I said, ma'am.
What
I
did
said
you
was,
say?
what I said was the applicants wrote for a zoning determination and an enforcement decision in writing to the part-time building inspector who was formerly here, Mr. Armstrong. His response to that request for a zoning determination and enforcement was, I do not see that there is any evidence of a change of use, and I do not feel that the electrification of the building is necessarily a change of use within the meaning of zone. It's an appeal from that determination that is before you. If you look on the first, I have a 24-page packet that begins with an application for an appeal of electrical permit, stamped received November 13th, 2025 by the town clerk. The next 2 pages are a letter dated November 13th, 2025 from Mr. Danahy. Exhibit A to that document is a letter from Paul Armstrong.
No,
Is it
Exhibit
as the
A
electric-
is, Exhibit A is the 2001 building permit.
Right, that's a different Exhibit A. There are multiple letters from Mr. Danahy in the packet that I have. That is Exhibit A to a June 30th, 2025. I am looking at Exhibit A to the November 13th, 2025.
You know, sir, I just asked you, I thought you had said that we could make a motion to overturn the building inspector's permit authorizing the electrification because he did not find it was a change of use. We could vote.
No, I did not say that.
Okay. Did you
I said that you
repeat
could
what
make-
you said? Just what you said?
I said that you could make a motion to overturn the building inspector's determination that there was no evidence of a change of use on the property for zoning purposes. The specific language that he used, the reason I was directing you to his email is that, quote, first, thank you for your patience with this department. As to the electrical permit issuance by this department, as we discussed, I do not feel that the electrification of a structure changes its use. So to the extent that they sought zoning enforcement on the basis that the electrification of the building necessarily changed its use as far as compliance with the special permit, the building inspector said, no, I do not think it does. You can make a motion to overturn that decision. That is not the same thing as overturning the issuance of the permit. Those are two different things.
Again, I thank you, I appreciate that clarification. And if we make that kind of motion, could we then continue the hearing to take evidence from the country club, the owner of the country club, as to what their intended use of the now electrified structure is?
It depends upon what you do. If you close the hearing, you can't take any more evidence.
But
If you
I could
continue
make
to
the
hear-
motion and not close the hearing.
No, you can't make a motion, you should not and cannot make a motion to render a final adjudication before closing the hearing. You need to take all of the evidence that you want to hear in and then make a decision on the outcome. If you vote to overturn the building commissioner, the hearing is over, you have made a final determination, that decision will be filed with the town clerk, it's subject to appeal under chapter 48, section 17. You would have nothing further to do once you make that decision as a board.
So that was kind of why I was trying to get to the point where the special permit seems to be changed could we ask the board to say the building that was put out there and has been built, since it's not on the special permit, could we say is a minor or major modification, leave the appeal open, and continue that so that we can then ask Indian Pond Country Club to submit proper plans and use of that building to be put into the special permit?
I
I
think-
think what you could do if you wanted to do something like that is, what I would suggest procedurally is that you continue the hearing to a date and time certain, ideally with sufficient time for anybody from Indian Pond Country Club to respond. You would invite them to the next hearing. You would invite them to submit plans, documentation, arguments, memoranda of any kind they wanted to submit, showing that, you know, they're in compliance with the terms of the special permit as it relates to the use of this building. You can ask them in a communication to address the fact that the use of this building does not appear to be documented by the records that are on file with the town clerk and in the town building department. You could ask them to supplement that in the event that anything was misplaced, lost, not found, despite a diligent search. You could ask them to do all that, and then you would have all that information available to you before you made a final decision on the resolution of the appeal that's before you.
That's
So you
basically what I'm
take
getting
all-
at. But,
Yeah, you could-
but how do I get that? The bigger problem is he doesn't have to give us that information. So how do we,
No.
this is like pulling the teeth out of an alligator. You know what I mean? How do you get, how do you get that information to happen? And like, how do you get it to come forward?
Well, the other thing you could do is that in the intervening time, you could also include in that communication, you could ask for their consent for an inspection of the property by the individuals who are currently serving as building officials and zoning enforcement officers within the town. And it's for the purpose of ensuring compliance with the terms of the special permit. I'm sorry, was there a question?
I'm just,
Can
oh,
I-
go ahead.
Can I ask? So it looks to me like the status of this permit has been issued. Is that correct? This electrical permit has been issued.
Yes.
And
Correct.
so if we ask Indian Pond to come back, my opinion would be that until we get a permanent building commissioner on site, I mean, they can go ahead and electrify this now. They have the permit. They can do what they want.
This is electrified.
Right. And we don't know what the use of it is. It's never been occupied, it's never been signed off by any inspections, by any framing permits or any of that. And, you know, shame on the town for not following up on that, but I would like to have a permanent building commissioner hired to review the status of this, to look at the building. You know, that's the building commissioner's right to see what the use of it is. If it's being used in a way that you had said that the fire department, if they're storing things that they shouldn't have, is it sprinklered? What's in there? And I think that's the right of the building commissioner to inspect the building to see, to make sure that it's not being used in a way that we don't know.
Yeah, and typically, on a
So
complaint like this.
just one other thing is, I don't want to approve or deny anything that's speculative. As a board, I'd like to see black and white in front of me. The question is, do we switch off the permit that's been issued? I don't think that that's our right to do that, but I think it's our right to ask what the use of the building is, since it's never been inspected. And I would ask that we continue to look at this building until we get a permanent building commissioner to go into the building and see what's going on. That's my opinion.
So is that something for, I'm asking the rest of the board too, is that something we can entertain? You know, like, again, continue the appeal that's in front of us, but then request, you know, like I said, I don't know how to do it procedurally with the fact that we say, we feel that this is a major modification to its special permit, and we would like you to come in front of the board and show us this building, what it is, how it's, where it's laid out. Again, I don't think that's in any, the special permit's it's one page. So there's not much to it.
So what I would tell you procedurally is that what you're contemplating is, you would have somebody go and do an inspection, whether there's a consent inspection or the town would need to obtain an administrative search warrant to view the building to determine whether it's in compliance with zoning and the building code and the electrical code. Typically, you would do something like that to look into it if a building official feels that it's warranted. You could ask, certainly as a board or individual members of the board, you could ask the building department to undertake that work. It wouldn't resolve this appeal, but also nothing in this appeal would prevent the town from doing that. The ordinary procedural course would be that if the building department does an inspection and they uncover something, whether the property is in some way not in compliance with the terms of the special permit, in compliance with town zoning, in compliance with the building code, you would have a notice of violation issued. Then you would see whether there was an appeal from that notice of violation. And if there was not an appeal from that notice of violation, it would become final. The building official would start issuing fines. The town could theoretically pursue an enforcement action in a civil court. But and I don't want to keep returning to this, but the question for the board on this appeal, and whether you want to have additional information before you answer that question, is within your discretion. That's entirely up to you. But the question is, do you feel that the building inspector's determination was wrong based on the information that was provided to him? And so,
I guess the other question, I just see the status approved. I haven't seen the permit application. Where's the power coming from? If it's not electrified, is the power coming from a substation? Has Edison, N-Star, whoever that is, have they approved it? Do they have, is all that electrical power approved? I mean, is it underground? Is it overhead?
So if you look on the second page of the permit, which just has, it appears to be like a screen grab from the town's electronic permitting portal, you can see that it's an electrical permit, and if you look on the second page, there's an estimated cost. Below that, there's a project description that says a new 200A, that's usually 200 amp electrical service from an Eversource transformer, type of electrical work, underground service with trench. So it looks like an underground electrical connection.
So the
from-
Eversource has to have, that they're permitting, so they have to excavation permit to get out there, has to be inspected by them, signed off by them, signed off by our electrical inspector that it's up, that the conduits are encased in concrete, all of that.
Yeah, that's all.
It just seems to me that, we're gonna put power there. Again, there's a whole process involved with it that I don't see.
It's
Now,
done.
maybe it's there, it's just not in front of us with that. So I depend on the electrical inspector to have gone through that process. I'm assuming he has. But I still,
Right, we don't-
my opinion, again, my opinion is, let's get a building commissioner here to review. I mean, are they gonna have an illegal casino in there? We don't know what the heck they're gonna be doing in there. It's all speculation. I don't like to approve or deny speculation. And to me, this is one big speculation.
I guess I'd like to try to make a motion. How's that? We give it a stab?
Yeah, give it a stab. I want to see
All right.
what you say.
I move that we continue the hearing, the appeal hearing before us tonight, and invite the representatives of the Indian Pond Country Club, the owners of the Indian Pond Country Club.
I think we would have to, I think we have to instruct the building commissioner to do
Yeah,
it.
that's up to him to do that.
We
can't-
only
we
can
can't
funnel
do
to the building inspector or the zoning enforcer.
Right, because just said, they could say, no, we're not coming, there's no
Yeah.
reason for us to be there, we have our inspection.
Again,
we
I
have our
thought
permit."
council said we could do that, we continue it.
The continuous, I
We
agree
could
with.
definitely continue the hearing, we don't have enough evidence to do really much of anything. I'm not sure to find out, and to find out what has the use of this building been, and do they intend to change the use? If they don't want to come, they don't have to come, but at least that will be some, use that, I thought, that's some indication, and we could set the hearing far out.
Let me, town council, what would be the proper wording to basically, I get what she's trying to say, we want to request to get information from
Building commissioner.
a building commissioner to go
department.
in there and inspect and see if there possibly is a change of use, since we don't know its original use to begin with,
We need a building committee.
that would allow it to come back. So when she does make a motion, she has correct language.
Do we need do we need to direct somebody, or can't we just
We don't,
continue the hearing to a date way out, in the future? Direct them to please come to present information to us.
until we get a building commissioner, we can't,
Why can't we do that?
because we don't have a building commissioner.
All right, hold on, guys. Town council, please give me information.
In terms of the form of the motion, I think the only motion the board needs to make would be to continue this hearing to a date and time certain. You can have the ZBA secretary, you could reach out yourselves, you could say, I would like you to send a communication noting that this hearing has been continued. We are seeking a representative from the building department to attend. You could ask them to do the same thing and send a letter to Indian Pond Country Club and advising them of the continued hearing date, inviting them to attend, and the subjects upon which, you would like, as the board would like to hear from them on.
Does
But,
the
as
board have to, take not a vote, but a pooling and say, listen, we want to get some information? Because I just have a feeling, like she said, they don't have to show, they don't even have to let us in. So how do we move it? How do we basically move it?
So you don't, this board, you can't issue a subpoena or anything like
Right.
that. You would issue an invitation, but I would tell you that you're allowed to assign some evidentiary weight or value to someone's refusal to attend or provide information, in the course of making your decision. This is a civil thing, it's not, I don't think anybody's Fifth Amendment rights are being implicated. This is just it's a zoning map. So you can ask somebody to come, you can make whatever inference you can from the record you have at the time that you close the hearing.
And-
So if you want to ask the building commissioner to come and provide some information, to try to attempt to make an inspection between now and whatever date you choose for a continued hearing, you can do all that. But I think the only formal vote and motion you would need to entertain is to continue the hearing to do that, because that's the only thing that's within you. Let's say you invite the building department to send a representative and they don't. That's a matter of, I don't endorse it, it's not good comity between municipal departments and boards, but it certainly can happen. Similarly, if you extend the invitation to Indian Pond to attend and they choose to neither submit anything or to attend and provide any testimony, that's where it's at. Again, and the reason I bring up the fact that this is an appeal from a determination by the building inspector is because it goes to, one of the things you're gonna need to evaluate on this is, who has the burden of proof here? There is a party who's seeking action to be taken by the town's zoning enforcement officials, and they disagree with the determination that those officials made in the first instance. And typically, the statute doesn't expressly assign a burden of proof, but typically, the person making a contention or a proposition, in this case, that the building department is wrong, needs to put some evidence before you that shows why that decision was wrong and why this board should overturn it.
Counsel, in order to give evidentiary weight, as you say, to someone's declining our invitation to come to address concerns that we might have, should we be very detailed in our invitation to the country club? Would that be the more detailed, the better, the more evidentiary weight we could give it? I'm just trying to, I'm prepared for them not to come, but I would like to know that continuing the hearing and issuing the invitation is worth something, has some value to us if they decline to participate?
So the question of how much weight you place upon it is a question for the board as a collective, because you're gonna need to review the evidence and you're gonna need to deliberate and make a decision. Typically, you know, how that decision gets hashed out would be something that would occur in private, that is separate, you know, because you would hear evidence in public and then deliberate, but the final decision you could prepare in consultation with my office.
I
But,
understand
you know,
that. I was just talking about the letter. Would it be better to be very detailed for our request, or just say, please come? Just trying to get some free legal advice from you here, in terms of moving forward.
I don't think that you're gonna be harmed by asking the secretary to include some additional detail about what you're looking for. You're also, I think, free to say, if you have any concerns about it, I'm not aware of any prohibition on you writing individually and saying, I'm a member of the zoning board, we are hearing an application concerning your property. I am inviting you personally to come and attend and give the board, because we are grappling with these specific issues and we would appreciate your input on them. You can approach that however you see fit. It's not really a legal question. I mean, how much weight at the end of the day you assign to it is going to be up to you, because you're the individuals who view and weigh the evidence in light of your common sense, your experiences, your reason. That, I think, you know, certainly the manner in which you communicate with an individual informs how you view that, but I don't think it legally binds you to one or another interpretation. You're all free to view the evidence however you see it.
So someone want to make a motion to continue?
I move
And then we need a
that we
date.
continue the hearing.
April 1st, April 15th?
I say
or-
April 15th. That's me. I don't care if it could be 1st or 15th. I just, first is the first one. April 1st. Oh, yeah, yeah,
There's
yeah.
nothing on the books right now.
That's so no matter what we'll be selling.
Tax day.
Yes.
That's perfect.
And then, so the motion would be continue it to, what did I say, April 15th?
15th.
I think there's already one scheduled for the 15th, isn't there?
No, not for April.
I thought
We
there was
have
a,
March 4th is 19 Rocky Nook, and then the following March
so I just want to, yeah,
18th
on
is
Rock,
Ford
there's
Road.
there's a addition at Rocky Nook?
Yep,
Yeah, all right, that's March?
March
All right,
fourth.
I thought that was April, okay.
There's nothing around April 15th. There's no, like, school or vacation stuff. Just trying to make sure that we're all going to be here. Tax day, yes, we'll all be here. All right, so we got a motion to continue.
Just one,
Is it April?
one
vacation?
other additional question. Can we,
Hold on.
can we ask the motion
Tax days usually.
to continue until we have a building commissioner?
Yeah, I know, that's the
I
bigger.
mean, we don't have a date, we don't have a building commissioner. Shouldn't we just say, we'd like to discontinue until we have a full-time building commissioner?
I don't want to.
Can we do that?
I think I don't know if we'll ever have a building commissioner, from what I've heard.
Whether or not you will, you can't continue a hearing indefinitely as a matter of law.
Okay, that was my question.
All right, then how about April
You can only,
1st?
you can only
That's-
continue it to a date and time certain.
Okay.
If on that date and time you still don't have what you need, you
Maybe
can
April
continue
1st
further.
instead.
But you would need to do that.
Well, I might not be here for, I think he's saying that's April vacation.
I would probably be recusing myself from any more.
Well, May 1st, I don't know when that, you know.
Oh, we could do May 6th.
Is that, so is that the next one?
Yeah, that would be May 6th. I can do May 6th. There's nothing there, right?
That's fine.
All right.
We'll still do the first one again, right?
Yeah, nothing there. So motion to, Marcia made a motion to,
To continue the hearing until May 6, 2026.
can I get a second?
Second.
All in favor?
Aye.
Thank you, Mr. Chairman. Thank you, board members. Thank you.
And then I guess as
Madam
a
Clerk.
board, can we, collectively ask the secretary to send out some sort of correspondence to the country club requesting
Come
that
together
they,
and send it out.
and then if not, I guess at that next meeting, we can request that the building inspector or the building commissioner or zoning enforcer goes out there and does a, inspection maybe prior to the meeting.
Okay.
Is that okay, town council? Are we allowed to say that?
Yeah, that's fine. And I just wanted to also advise you, I am departing my current position, and so I will not be here for May, but what I'm going to do is brief Jay Tallerman, and I will let him know about everything that went forward tonight and the information and arguments that were presented here, along with the questions from the board, and so we will have somebody ready to assist you when it comes time to reconvene this hearing in May.
Very good.
Sorry to see you go.
Thanks, it's been a pleasure. I appreciate working with all of you. It's been an honor. Sorry to go, but we just got a
Best of
great
luck to you.
We'll see you on the other side, right?
opportunity. Yeah. Thanks.
Take it easy. Thank you.
Is there anybody that we should have asked?
No, I thought about that, but,
Okay.
someone want to make a motion to adjourn?
I make a motion, we adjourn.
Can I get a second?
Second.
All in favor? Aye.
Aye.